Good morning, everyone. Thank you for joining us today. My name is Hanaa Sharief. I am an immigration and estates and trust lawyer and partner at McInnes Cooper, based here in Halifax, Nova Scotia. We are going to discuss the Atlantic Immigration Program today and dig deep into it. The purpose of this webinar, it's directed more at employers and to give you tips and tricks given the different processes that are available in the different provinces. We're going to discuss, we'll begin with an overview and background about the history of the program, and then discuss the application process, the eligibility requirements, both from the employer and the candidate side. And then we will end with a conclusion of the cons and pros, and also some of the recent trends in the different Atlantic provinces and the investigations and increased compliance that we are seeing across the region. A bit of a background on the Atlantic Immigration Program. Let me just go back with a bit of a history. The AIP offers a unique opportunity for employers. It started in 2016 as a pilot program. It was as a result of an agreement between the four Atlantic provinces and the federal government. The purpose of the program was to emphasize the collaboration between governments, employers, communities, and settlement agencies to ensure successful immigration integration. So in July 2016, the governments of the four Atlantic provinces and the federal government launched the Atlantic Growth Strategy. And as part of that strategy, the Atlantic Immigration Pilot Program was launched. And the idea behind the program was to support employers in Atlantic Canada to address regional labor market needs, but also to increase newcomer retention in the region, because the Atlantic provinces were experiencing difficulties in keeping temporary foreign workers and permanent residents in the province who were usually coming in, getting their PRs, and then moving to the larger provinces. So the AIP was launched to support the Atlantic provinces in retaining temporary foreign workers once they become permanent residents in the province. The pilot program brought over 10,000 new permanent residents in Atlantic Canada and created over 9,800 jobs in key sectors such as construction, healthcare, manufacturing, food services, and accommodations. The pilot turned out to be a success, and eventually it was initially a 3-year pilot program, and eventually it was extended for 2 years. And in December 2021, the provincial governments and the federal government decided to launch the Permanent Atlantic Immigration Program, which had some changes to make it easier for employers to support temporary foreign workers to transition into their permanent residency. The Atlantic Immigration Program is different than the existing provincial nominees programs in that it is an employer-driven economic pathway to permanent residency only available in the four Atlantic provinces. What it does, it allows the employer to control the process of the permanent residency in supporting the candidates by submitting an endorsement application on behalf of the employee or the candidate. And to begin that process, they can avoid the more cumbersome LMIA process, but still they would need to show that there was a labor market demand and that they weren't able to find qualified candidates in Canada that are Canadians or permanent residents. But the recruitment is a little bit more easier than the LMIA, and depending on the urgency, the processing times for an endorsement can be much faster than it is to obtain an LMIA and then go through the work permit process. So it is employer-driven in the sense that the employer has to do the heavy lifting at the beginning by submitting the endorsement application on behalf of an employee, as opposed to the individual submitting an application, for example, under the nominee program on their own, where the employer role may be simply limited to providing them with a job offer and a simple form that outlines the terms and conditions of the employment terms. So to begin with the process that is involved, the employer has to be designated, and we will talk more about the employer designation and what are the eligibility requirements for an employer to be designated. But the first step is, before you can even offer a temporary foreign worker inside or outside Canada a job offer, the employer has to be designated first. So you go through the designation process. Once you're designated, and provided that you have done a recruitment, if the employee isn't working for you already or is not inside Canada on a LMIA exempt work permit or on a closed work permit already working for you, you have to do the recruitment, and then you provide the employee with a job offer. Once the employee has a job offer, they then have to go through the process of obtaining a settlement plan that will come back to you as the employer to sign. And once that is in place, you then submit the endorsement application. This is where you are taking care of the process. And we will discuss later on in the presentation the differences between the provinces on how they handle the endorsements application and how the process can differ from, really, is it fully employer driven, or is there a collaboration between the employer and the candidate, and which province seems to be easier? Once an endorsement application is approved, you then provide the candidate with the endorsement certificate. And if you had requested a work permit support letter, you also provide that to the employee, and then they can apply for both their work permit and PR at the same time. But the work permit application is optional. So if you have a candidate that is already working for you and their work permit has at least 2 years or at least 18 months still of a validity period, they may not need to apply for a work permit. But if their work permit is about to expire, they're likely going to need the work permit support letter to extend their status. If you are recruiting from overseas and you want to bring a temporary foreign worker for a position that you have not been able to fill from inside Canada, then it is likely, given the urgency, and that you would want them to apply for a work permit so that they can come and begin working for you while their permanent residency application is being processed. And then finally, if everything has been done correctly and the employee has submitted the correct documentation at both the work permit and PR application stage, it should be approved. What I would want to note here is that an AIP work permit is like a mini PR application, and it requires a lot of documentations to be submitted to the federal government. So it's not like a postgraduate work permit for international students or an open spousal work permit, where you simply provide a few documentation and you expect to be issued a work permit. It is actually document heavy, and the employee, essentially at the federal stage, still has to convince the IRCC officer, despite having been endorsed by the province, that they meet the requirements of the program. So we see a lot of refusals for candidates that attempt to apply for the work permit once they are endorsed on their own. So that's something to take away from this webinar today, is that if you are spending the time and effort in the Atlantic Immigration Program and want to support your employees or potential candidates, to consider assisting them and supporting them in their applications for the work permit and the PR. In order to, so we'll move on to the designation process and what is the eligibility in order for an employer to become designated. So not every employer can automatically become designated. You have to be in active operation under current management in the Atlantic region for at least 2 years. And you have to be in good standing and compliant with provincial and federal standards and legislation. So you can't have any human rights complaints active human rights complaints against you or labor standards complaint. And in some provinces, you actually have to provide certificates and proof that you're in good standing with workers in Newfoundland, for instance, and with the labor standards. So this is important. If you have any complaints against you, then the program is not available for you at the time when you have active complaints. As an employer, you're also required to complete 2 mandatory trainings. One training is a free onboarding training with IRCC. It's a virtual training. You can watch it. You register for it by emailing IRCC with a request to complete the training. They send you a link. Essentially, it's a webinar. I believe it's currently like on YouTube, and you watch it at your convenience. It's about 2 hours, and it basically gives you an overview of the program, the steps involved, the process, and so it's pretty straightforward. And the second training is an intercultural competency training that you have to complete with a designated institution and settlement organization by IRCC. So in Nova Scotia, that would be the YMCA or ISANS. So it's pretty easy as well. It can be in person or virtual. Once it is completed, you then get a certificate confirming it has been completed. The individuals who are required to complete the trainings are the individuals who are going to be representing the employers with the AIP process, and they have to be not essentially authorized officers. But they have to have the power to make decisions for the employer in hiring and firing, increasing pay for the employees. So they have to be involved in the day-to-day management, and those can be authorized by the signing officers to be the employer contact on these applications under the AIP program. So any individual within the company who's going to be representing the employer as the employer contact in the AIP program will have to complete the training. And essentially, we recommend that you have at least 2 people complete the training within your HR department. Generally, those are the individuals that will be involved with the program, so that if one of your contacts is on vacation or is no longer with the company, you won't have an interruption, and you will continue to have an active employer contact that continues to deal with the provinces with on any existing endorsements applications. As an employer, to benefit from the Atlantic Immigration Program and become designated, you have to commit to meeting the settlement needs of international candidates and their accompanying family members. And that is where the settlement plan comes in, where the settlement organization will identify what are some of the needs of the newcomers or the existing candidates that are already working for you, and you can commit to supporting them with language training, supporting them by picking them up at the airport, showing them how to get a SIN number, how to enroll their kids in school, and so forth. So it depends. The settlement needs will vary depending on whether the candidate is inside Canada or outside Canada, but you have to show that you have a commitment to be supporting the international candidates with the settlement. To become a designated employer, you also have to ensure that you're not getting designated simply for the purpose of creating a pool of international candidates that you are recruiting so that you can later transfer them or contract them out to separate businesses for staffing purposes. It also means that you can't recruit potential candidates because you know you're going to have a project in the future, or you're expanding and you just want to start the recruitment process early on, hire the individuals, begin the process, and then bring them over to Canada once you are ready to train them or you have the position available for them. So when you are getting designated, you have to consider your immediate needs and that you're not simply going to endorse applicants to create a pool of available candidates for you. That could get you de-designated and investigated by the program integrity units of each province. An employer has to have a brick and mortar business, so you can't be completely home-based business or have a telework policy. You have to have a brick and mortar business, and in the different provinces, they're developing some policies with respect to telework arrangement and when it can apply and when not. Newfoundland is more flexible, but Nova Scotia, New Brunswick, and PEI are not as flexible with the telework policies, and they will assess them and assess the criteria depending on the size of the business, how long you've been operating, and how long the candidate has been working for you before they will allow them to benefit from telework arrangements. Finally, the AIP is only available for skilled occupations in the 4 tiers, 0, 1, 2, 3, and 4. Tier 4 categories are not eligible for endorsement under the AIP. With a Tier 4 position as an employer, you have an additional obligation in that, and we will discuss that later, the job offer has to be permanent, but you also have to undertake to cover the cost of returning the worker to their home country if your designation is revoked, or if you terminate the employment of the employee for whatever reason, with or without cause, you would still be responsible for returning them to their home country. Some of the steps involved in designation that creates a heavy burden on employers is that one designation application will not be sufficient in each province. If you are going to be supporting employees across the different Atlantic provinces, if you have a regional business, you will need to get designated in each of the provincial government in which the candidate will be working. And you will notice that the process for designation in each province will vary. In your designation application, you have to identify your labor shortages, determine the NOC codes that you want to hire, the number of positions, and the salary range that you're offering per NOC. And in addition to that, you are subjecting yourself to compliance by the checks by the provinces, in that they will review the designations, or at least under the ministerial instructions for the AIP program and the agreements between the provincial governments and the federal government. The provinces have an obligation to review the designations every 2 years to confirm that the employer is meeting its labor shortages and providing genuine job offers, but it's meeting the idea is that they want to ensure that employers are endorsing candidates that they have initially identified in terms of the NOC codes and the positions. And basically, we've seen cases recently where the provinces have come back to the employers to say, you've already endorsed 4 applicants in this NOC code, and that's the number of applications or positions you've identified in your designation application 2 or 3 years ago, and therefore justify the need for this additional position. So it's not sort of a program that's unlimited for you to use as you wish. You have to think about it in terms of your future demands and whether you're doing it as a result of an expansion or is it a result of losing some employees and so forth. Newfoundland actually in particular this year changed its process, and now you have to identify the positions you have to fill for at least 3 years, and it becomes more transparent because they can now see how many positions you have endorsed. They will assign you particular endorsement spots for the number of positions you have identified. So they will be able to track if you've used all the positions or not. And so you can't just simply submit an endorsement application for additional position if you have already exhausted the number of allocations they have provided to you. Whereas in Nova Scotia, for example, you can submit as many endorsement applications as you want, but you then might be questioned if the endorsement applications exceed the positions you have identified or are for a NOC code that you hadn't identified in the beginning of your designation or your initial designation application. It doesn't mean that the applications will be refused, but it means you will be questioned and you'll need to provide explanations as to why you are engaging in endorsement of a new position. The program is not it's not intended to penalize employers. It's actually here to assist employers, but the provinces want to ensure that it is used for the intended purpose, and the job offers that are being provided are genuine job offers. And this is particularly as a result of abuse of the AIP program, because it was seen as a shorter and faster pathway to PR than the provincial nominee program. And we've seen some employers were selling jobs to overseas candidates in order for them to get their PR, but the job offers were not genuine. So the provinces are ensuring that there is compliance and increasing the compliance checks on the designated employers to ensure that the job offers are genuine, and they're not simply creating pools of candidates that they will then, use as a staffing agency and send to other employers. In addition to identifying the labor needs and shortages at the outset, your obligation as a designated employer is continuous. So when you have a change in your ownership structure or management, you have to advise the province. So it is unclear. The guides simply say you need to advise them of a change in your ownership structure or management, but it's unclear how that is to be completed. A change in ownership doesn't necessarily mean you will get de-designated, but it may mean that you need a new designation application or an updated designation certificate. So in Nova Scotia, and in PEI, you would simply, actually in all the provinces, you just have to provide that information to the province, and then they will tell you whether you'll need to apply for a new designation or they will update your designation certificate. It's basically decided on a case-by-case basis. There isn't a clear guidance. Interestingly, Nova Scotia recently created forms on their online portal that are not publicly available, and an employer will only get access to them when they send an email to the province to advise or notify of a structure or ownership change, and then they will receive a link with different forms, online forms that they can fill out, whether it is to update a change in the directors or officers, to update or to withdraw their designation, or add more employer contacts. So there are different processes in the provinces that are not necessarily publicly available, and we learn about them on a case-by-case basis. If there is a change in management, and in the complete management of the business, that would result in de-designation, and you'd have to operate for at least 2 years under the new management before you get the opportunity to apply for a new designation. So if you are in the process, for example, of a sale of the business and are considering bringing on new management, you want to consider the timing of when you do so. If you already have existing endorsements applications that are in process, you may want to sort of wait it out and see the potential consequences that you may face. We pose a couple of questions to the provinces on the same management requirement. And what does that mean? For instance, if you have a small business that has a mom and pop shop that has the owner is the manager, is essentially, they don't have like the office manager as well, they don't have a management team, and they are selling the business, that essentially means they're going to get de-designated, because there is not just a change in ownership, there is a change in management. But if you have a large organization and you have some individual in the management team that have left the company, but overall there are some individuals that are still with the company, that doesn't necessarily result in a de-designation. You just simply will have to update the employer contacts in your designation application. Newfoundland and PEI are very flexible and facilitative, and so and New Brunswick as well. Nova Scotia can tend to be a little bit more on the difficult side, and they will ask you for organizational charts. They will ask you for updated registry of joint stocks to ensure that the managers are the same. So if you, for instance, change the directors and officers in the joint in the registry of joint stock for your business, that can be seen as a change in management. So you sometimes have to provide an explanation to indicate that even though the officers at the registry level have changed, that doesn't necessarily mean that has been a change in the day-to-day management team, and this should not result in de-designation. So that's something to note. If there's a change in business and the corporate registry number changes, you may need to submit a new designation application so that when an individual is submitting an endorsement application or a PR application, the feds are able to match the application with the designation number of the employer and their designation certificate. So there are some reasons why the provinces can tend to require additional steps and regular updating once you have been designated. It's more so to ensure that the feds can match the applications in progress to an existing endorsement. On the change of ownership, I just want to highlight a question that we raised with the provinces last summer, in which they confirmed a change of ownership doesn't necessarily mean de-designation, but clarified that if there is a simple successory interest sale where both the liabilities and assets of the business are purchased, that will not result in de-designation, but you will get a new updated designation certificate may be required. Again, those are handled on a case-by-case basis, depending on the provincial officer essentially that is looking at your application. Sometimes you have to reach out to program directors to explain why you don't need a new certificate or a new designation application, and simply the province can provide you with a new designation certificate with a new number, but it depends on the program director and the province that you are dealing with. Once you have been designated, you then have to provide the employer with a job offer. A job offer in a particular form from IRCC, it's IMM 0157 form. And this form essentially sets up the terms and conditions of the offer, the tier, the duration, the educational and qualifications that are required for the job, the location of where the individual will be working. And the job offer has to be provided to the candidate or made within a certain period of completion of recruitment. So if the candidate is not already working for you and you're recruiting internationally, and therefore you have gone and done the recruitment where an advertisement is done for 4 consecutive weeks in at least 3 locations, one which has to be national, such as the job bank. Once the recruitment is completed, within 6 months of the completion of the recruitment, you have to provide the candidate with the job offer. In addition to the IMM 0157 form, you also have to provide them with an employment contract with clear terms and conditions of their employment. In the case of a tier 4 position, the language on the contract, the position has to be permanent. And so the language on the employment contract has to specify that the position is permanent and without an end date. Interestingly, in Nova Scotia, we have found cases where employment contracts that are without an end date, so they're essentially permanent, the officers have come back to us and said, you have to write the word permanent on the contract in order for us to approve this endorsement application. So the provinces can be a little bit picky in how you identify or classify the job offer. The job offer has to be full-time of at least 30 hours per week. It cannot be seasonal, so the AIP is not available for seasonal employment. And the wages offered can be within the wage range for the position in the region where the individual will be working. So that is one of the benefits of the AIP, is that the wage offered doesn't have to meet the median wage, and it can simply be within the wage range for the particular NOC in the region where the employee will be working. The IMM form has to be signed by both the employer and the employee. And it also, the employment contract has to be signed by both the employer and the employee. And both have to be signed by wet signatures. So digital signatures are not allowed. And we have seen officers come back on various occasions, particularly in Nova Scotia, and asking the employer and employee to re-sign everything with wet blue pen to ensure that it was wet signature. So for a small organization where you're doing 1 or 2 endorsements at a time, that's not a problem. But if you're a large organization and you have one HR individual that is handling these applications and you're submitting multiple applications per month, this can be a tedious process, but this is one of the requirements that the provinces will not change or agree to sort of negotiate on. The wet signature is required. Once the employee is offered the job, they can then use the IMM 0157 along with a copy of your designation certificate and apply for an appointment with a settlement service provider to get their settlement plan. And so the settlement plan it is issued. It's essentially, the time it takes to obtain an appointment varies depending on the settlement organization and how busy they are. Sometimes it can be weeks and sometimes it can be months, depending on the timing of when you're planning to submit. We found 2 years ago that it was taking months to get a settlement date to get a settlement plan. But now that the AIP is not used as much, it's quicker to obtain a settlement plan. But once the settlement plan is obtained, both the employer, the employee, and the candidate's spouse, if they have dependent family members accompanying them, would have to sign the settlement plan. As I said, the settlement plan has to be signed regardless of whether the candidate is already actually working for you or not. So it means that sometimes it can be cumbersome, it can be expensive, because you can just waste time in getting an appointment to simply say no settlement support is needed because the candidate is already living and working in Canada and already established. So it is one of the downsides of the AIP, is this requirement for a settlement plan for everyone, regardless of whether they are in Canada or not. The next step after a settlement plan is obtained is you go through with the endorsement application. Now, the way that an endorsement application is submitted varies between each province. Each province has their own portal, so all applications now, whether designation or endorsement, are submitted online. Each province has their own unique AIP portal for endorsement applications. And it essentially is easy. It's the easiest, I would say, in Nova Scotia, even though we have a new online portal. So in Nova Scotia, to get designated, you submit the designation application through the Nova Scotia online service portal. But as of May of this year, for endorsement applications, they moved to a new system where it's a little bit different than in the past, where you could just simply, in the same portal where you've been designated, begin an endorsement application. Now the authorized signing officers have to, within the new portal, appoint their employer contacts that will be responsible to submitting applications, have communications with the province, and then they would appoint their authorized legal representative that can be preparing the applications on their behalf inside the portal. So in the past, we would draft as representatives the endorsement applications, get the employer to review, and then submit on their behalf. This has now changed, and the province wants to ensure that the employers are in control of this process, so they can assign the representative per application or for all applications. And sometimes it allows representatives of the employee now to be engaged and able to support them with the endorsement application by ensuring that the candidate's information that they are presenting are accurate. So Nova Scotia has recently changed it, but it still would be considered one of the easier programs. PEI doesn't yet have a portal, so you simply click on the link on a website and you just begin filling out the online form, but you don't have the option to save it and come back to it. So if you don't have all the information available and you don't know what questions you're going to be asked, you're then have to redo the endorsement application, the designation application. And also with the endorsement, you'll have to submit the information, then you will get a link if they are satisfied with everything that you provided to upload more documents. So it's not as straightforward. They do their own assessment and then they provide you with a link to upload documentation. Whereas in Nova Scotia, once you're authorized to submit an application, you are in full control and you submit all the documents at once. New Brunswick, it's a process that involves both the employer and the employee, in which the employer begins the endorsement application in their portal. The employee can then allows the employee to have access and submit the relevant information about them, and then the employer submits the endorsement application. Newfoundland this year completely changed their system in that they now require the employer to submit a request for an endorsement. That creates a code that is then provided to the employee that can then set up their expression of interest to request to be endorsed. And only if Newfoundland has invited the candidate to apply for endorsement and selected their expression of interest, then the employer can submit the endorsement application. So there is that step, the extra added step for the province to be in control of the endorsement applications that are being submitted. So Newfoundland used to be the easiest province in terms of the AIP and the PNP, but we've noticed recently with the change of their system for an expression of interest based system for both the AIP and the PNP that they are now fully in control of the applications. So that's something to watch for if you're an employer in Newfoundland. But Nova Scotia still remains one of the easiest, along with New Brunswick, for submitting endorsement applications directly without a limitation or involvement from the province. One of the downsides of the system in Nova Scotia, for example, where you as the employer are fully in control of the endorsement application and provide, where you have to provide information about the candidate eligibility, you really need to provide information about their valid work experience. So you're doing an assessment to ensure that they are eligible for the position that you're offering them. You have to review their proof of work experience, whether it's experience letters from previous employers, pay stubs, tax returns. You have to look at their education and ensure that they are providing you with valid education documents. And if their education is foreign, you want to make sure that they have an ECA. You also have to ensure that their language test results meet the eligibility criteria for the position and tier that you have offered them. So as an employer in Nova Scotia, you're not simply providing information about yourself, you're actually doing a mini immigration assessment for the employee. And that's why I think with the new system where they allow the employer to assign a representative per application or for all applications, you could then have the employee's representative that you don't have to be involved with verifying that information and providing that information for the candidate, and you're only responsible for your own information. But we haven't seen how that has worked in practice yet, because the we haven't been applying for endorsements recently, given that the province is limiting the applications to priority sectors. So the PNP seems to be better in that regard. The timing of submission of the endorsement application is really important, particularly if you have engaged in recruitment activities and are recruiting, for example, from overseas. So the candidate is not already working for you, or their work permit is about to expire and you had to, you didn't have the time to submit the endorsement while they were still working for you, so you had to do recruitment. The guide says that you have to submit the endorsement application, or you have to provide the job offer within 6 months of recruitment, but there's no direction as to when you are to submit the endorsement application. And as I indicated, with an endorsement application, you are not just submitting information about the position, you are submitting substantive information about the candidate's eligibility in terms of their language, work experience, age, and so forth. So in order for you to submit a complete application, sometimes candidates don't have all of their documents ready as soon as you provide them with a job offer. And some of them may have difficulty obtaining work experience letters from overseas. And so instead of submitting an application with some information missing, or you could get a message to say, in New Brunswick, for instance, and PEI, they're a little bit more facilitative, so they will wait until you provide them the documentation. In Nova Scotia, if you're unable to provide the documents within a certain timeline, the application will be closed or refused. So it can take you some time to obtain the required information. So if it takes you up to a year to prepare an endorsement application from essentially the end of recruitment, the application in Nova Scotia, for example, they will say that you've submitted the application too late and they will require you to undergo new recruitment. Newfoundland said if you provide them with the endorsement application within 12 months of recruitment, they are going to accept it, and they might ask you for more information and documentation to ensure that the job is still genuine and there is a labor need. Nova Scotia is tougher, and we've had applications refused on the basis that it took a long time to submit the endorsement application, even though the employer had then gone and did an LMIA for the same position, because it was taking a very long time to go with existing endorsements application under the AIP, and that wasn't sufficient for the province. So I would say for Nova Scotia, you want to submit the endorsement application as soon as the recruitment is completed and you have the settlement plan. So ensure that the candidate have all of their documentation in place, then do the recruitment, and then submit the endorsement application. This is just to give you an overview of the documentation that you would have to submit. As I indicated earlier, you submit the IMM 0157 form, signed with wet signatures. If you are going to be requesting a work permit support letter for the candidate to apply for a work permit and begin working with you before the PR is approved, you have to submit an IMM 0156 form. What's interesting is that you are required to indicate information about the you have to sign a declaration that says that the applicant says, I have applied for, my employer has applied for an endorsement in this province, and we've received, approval or indication of receipt of the province of that application. And that's not really true. So I usually do not submit the IMM 0156 form until an officer reaches out and requests it, because that to me is a clear indication the province has received the endorsement, is looking at it, and I'm not instructing the client to sign a declaration that doesn't accurately reflect the facts. You have to submit, along with the endorsement application, a detailed job description that will accurately reflect the duties that will be performed by the employee. So if you just use the job ad, that will not be valid. Again, if you have done recruitment, you have to provide the proof of recruitment as you would if you had done an LMIA application, unless the candidate is exempt. And again, you provide all of the details about the candidate's eligibility. The benefits of the AIP is that once the employer is endorsed, you have access to IRCC dedicated service channel, which is an email and contact information where you can call have access to an IRCC individual that can support you with ensuring, the status of a work permit application or a PR application that has been submitted for an individual that has been endorsed under the AIP. So they can't expedite the applications, but they can look into the status. And every time we reach out to them, if there has been an application that was delayed or beyond in processing beyond the normal processing times, miraculously we get a decision, or the application is approved. So they are very supportive and helpful in that regard. But you get that access for only 2 years. So once you have been as I said, once you've been designated, submitted endorsement is issued, then it goes on to the candidate to submit their work permit and PR application concurrently. And essentially, you're not involved at that stage, other than if the individual is applying for a work permit, you would have to apply and provide them with an online offer of employment A number and a receipt confirming you've paid $230, which is a requirement under the International Mobility Program, to evidence that their job is LMIA exempt as a AIP endorsed candidate. So essentially, the candidate is responsible to go on with this process. You can support them as an employer, or they can do it on their own. Candidates eligibility, this is where I said earlier, you're providing information about the candidates. So you're doing a mini immigration assessment from the outset when you're submitting an endorsement. The job offers would have to be full-time, non-seasonal, depending on the tier. It may have to be permanent or valid for at least 1 year after the candidate becomes a permanent resident. Usually employers are providing permanent job offers to all their employees. The work experience, the individual has to have 1 year of work experience gained within the last 5 years. It could be inside Canada or outside Canada. One of the benefits of the AIP is that international graduates in Atlantic Canada that have graduated from an Atlantic university with a degree within 2 years and have lived in the province for at least 16 months within 2 years, they don't need to have work experience. The proof of funds is not required if the candidate is already working for you. The education is lower and easier than for PNP and other federal PR programs, depending on the tier of the job. And again, the language requirements are also easier than the federal express entry programs, for example. So for the higher skill tiers, you only need a minimum of CLB5, and for tier 4, you just need the basic CLB4. So the AIP has its pros for candidates in that the requirements are not as hard or high as they are for other PNP programs or federal programs. So to summarize in terms of the pros of the AIP, there is no age limit. It's great for old applicants, low language and education requirements, the lower work experience requirements for international students, lower settlement funds, and faster processing times. Although it is now, we're seeing that the reported processing times is 13 months, where initially it was meant to mimic the processing times for express entry PR applications of 6 to 9 months. That has essentially increased recently. The cons of the program, as you may have seen, there are various steps required. It can get complicated, especially for regional employers that are working in different in the 4 different provinces. Every time you want the employee to work in a different position, you'll have to update the designation certificate and the endorsement certificate. That you've got the continuous reporting obligation. You have to maintain the records for at least 6 years. And if you're involved with a settlement support, that can be expensive and burdensome for you. One of the also things about the AIP work permit, not just that it's usually refused because the candidates really don't submit the appropriate documents. Unlike the PNP, for example, work permits, you cannot submit an AIP work permit at the port of entry. So if your candidate is from a visa-exempt country and can generally apply for a work permit at the port of entry upon their arrival, once they are endorsed or nominated, that is not applicable for AIP work permits. Those can only be submitted online. To conclude, I want to give you just a quick overview of the provinces. We're noticing that the provinces are no longer going with a first in, first out model. They are focusing more on strategic industries to respond to their provincial labor needs. They are adding specific restrictions in that they're only looking at applications from specific occupations or specific industries, and the processing times in Nova Scotia are ridiculously lengthy, and thus we are not submitting a lot of applications in Nova Scotia for designation. You can have the application in progress for more than 12 months, depending on which sector you're in, whereas in PEI in Newfoundland, once you've submitted all the required information, it's in a matter of weeks, you'll get designated, and also the endorsement is issued pretty fast. But in Nova Scotia, it is taking the longest to issue designation and endorsements certificates. New Brunswick, of course, you may know, have already closed the AIP program because they met their quota. So we don't really know much about what's happening with them, but we've recently heard that they may still be processing applications under the AIP for individuals in the healthcare sector, but that hasn't been officially announced yet. All right, so I guess with that, that's just a bit of an overview on the AIP. And just in conclusion, I would say that we have seen increased compliance checks from the provinces, particularly in Nova Scotia, and now Newfoundland is beginning to do compliance checks on designated employers to ensure that you are using the program for the purpose it was intended for, to ensure you're filling your labor shortages and not simply supporting employees to get PR who might then leave you. I'm going to open it now for questions. I'm going to check. I believe there should be questions in the chat, but I have to. I don't see any questions in the chat, but if there are any questions that you have, please feel free to put them in the chat, or feel free to reach out after if you have any specific questions that you want to discuss in detail.
Hanaa, there's a couple questions in the Q&A area. If you want to stop sharing your screen, you should be able to go into that section.
Okay, let me just see here. Yeah, here we go. All right, so first question. So there isn't a link for the DSP program manager for an update on endorsement application. You'd simply reach out to the province to ask for a status update. They're generally not going to respond unless it's a priority sector, but there isn't a particular information. Like, we don't really share the information of the program managers because we have those in confidence unless the province shares it publicly on their website. So PEI, you'll find the details of all their nominee officers and program managers on their website. Nova Scotia, it's not available, so we're not able to actually share that information. So if you have been working remotely, if you do, depending on where you're located, you'd have to look at the telework policy of Nova Scotia, which is available on their website, and look at the number of employees. If you've been, if the individual you're endorsing has been working for you at least for 12 months before the endorsement. There are some particular criteria, but Nova Scotia is not flexible, and they will ask you for copies of the lease. At the minute you say that you have a remote working arrangement, they will dig in with questions, and they may find that you might not be eligible. So it depends on a case-by-case basis, but there is a link on the Nova Scotia website, if you are based in Nova Scotia, that to their telework policy to see if you fit within the exception or not. So if the employee is already working for you, one of the things I would actually note about the AIP is you don't need to provide you don't need to list all of the prior work experience for the employee. You simply need to show and prove 1 year of work experience related to the job. Actually, it doesn't even have to be related to the job. You look at the NOC. So the work experience has to be at the same or lower level of the job offers. So if they've already worked for you for 1 year, that meets the 1 year work experience. So you can use a letter from you to provide to the province setting out their job, the duties they perform, their benefits, but they would still need to submit tax returns. Nova Scotia in particular requires a lot of information. So they will ask you for their tax returns, pay stubs. So they should have that. And sometimes they'll ask you for bank statements to show the transaction of their salary. So the good thing is you don't need to provide letters from previous employers, but if the candidate is overseas, that's where the problem becomes, because they have to obtain those work experience letters from their employers. The settlement appointment is essentially a phone call. So they each organization has a different way of how they do it. For example, iSANS, the employee will set up an account on their website. They will upload the designation certificate and the signed IMM 015 form, and then that's all what they need. They'll have a phone call, they ask them questions, and then they complete the settlement plan, and they send it to the candidate to sign, to provide it to the employer to sign, and then it's provided to the settlement officer. So it's not an in-person appointment, but you don't need to have the original offer, you just need a copy. That should be fine. The training with IRCC or the intercultural competency training does not expire, but if the individuals who completed the training are no longer with the company, the new employer contacts will need to undergo the training, but that doesn't affect the designation, the existing designation status of the employer. You just need to ensure that the new employer contacts that will be handling the endorsements applications and dealing with the immigration offices and with the temporary foreign workers, they will have to undergo the training. I don't see any other questions. Can you apply for designation while you are recruiting for a position in case you may need to follow AIP with a new employee? So the designation, you can apply for designation at any point in time. The endorsement, you will only be able to submit the endorsement if you've completed the recruitment and were unable to fill the position with a Canadian or permanent resident. But the designation is not related to the recruitment that you are doing. The designation, you can submit an application at any point in time. I would just note that in the past, it was easier for employers to get designated. Now, as I indicated, in Nova Scotia, you can have the designation application in process for over a year because they're picking the applications, even though they're still doing designations, they're picking ones for employers in priority sector. I would note that the only benefit you would have as a designated employer right now in Nova Scotia is that you can recruit, depending on what industry you're in, you can actually recruit foreign workers from overseas. Otherwise, Nova Scotia is really just looking at candidates that are already in Canada under both the PNP and the AIP, but they will address endorsement applications for employers in the trucking industry, STEM occupations, for foreign workers overseas, and as well as I believe they're also looking at social services. So they look at the provincial needs. So that's the benefit of being a designated employer under the AIP currently. In the other provinces, regardless of whether you're recruiting inside Canada or outside Canada, as long as you're an employer in priority sectors identified by the province, they will assess your applications for applicants inside or outside Canada. I think I've answered, Jennifer, all the questions, but please let me know if I've missed anything. I don't see any other question, but please feel free to reach out and send any questions that you weren't able, to discuss today, or you haven't thought about by email. I'd be more than happy to guide you through it. I'd also encourage you to check our MC trainings on our website. We do provide certain trainings for employers on the Atlantic Immigration Program, and we can cater the training to your particular needs and demands, and provide more details with respect to the processes and things to do and not to do. We also have different trainings on the LMIA process and the employer compliance obligations that arise under different immigration pathways and program. Thank you very much, and I hope you found this helpful, and have a great day.